Strippers everywhere in Louisiana are celebrating. Stay tuned to the end of this video to find out why. On October 31st, 2016, Louisiana was supposed to start enforcing Act number 395. Now, what is Act number 395? Well, that would prohibit any stripper under the age of 21 to strip in clubs that serve alcohol. This would prohibit any strippers under the age of 21 from dancing at clubs that serve alcohol. So what did the strippers do? They filed a lawsuit against the state of Louisiana stating that this new law was unconstitutional. The attorneys for the strippers stated that their First Amendment rights, that's right, you have a First Amendment right to nude dancing. Their attorney stated that their First Amendment right was violated when the state enacted this law, Act 395. Now, Judge Barbier was required to make a ruling on this, and he has given us a 41-page preliminary injunction ruling. Now, when I was in law school, this would have been essential for my constitutional law class. It goes through a great discussion on your First Amendment rights and what the state is allowed to do and what is protected and what is not. Now, the intention of the act, or what the legislature was trying to get across, was that they wanted to limit human trafficking, which is a great cause. Now, what Judge Barbier ended up deciding was that this was a content-neutral law. Judge Barbier went on to grant the preliminary injunction, which means that Louisiana cannot enforce, ATC cannot enforce this law in Louisiana because he believes that the plaintiffs have shown that this law is overbroad and too vague of protected First Amendment speech. Nude dancing. Plaintiffs showed that there are other scenarios like people in theater or the ballet or plays or other things that have individuals that are under the age of 21 that are nude and that also serve alcohol. So this would not only affect exotic dancers but could affect others. So it would be overbroad. The plaintiffs also stated that the law was too vague, meaning it didn't define some terms that were in the act, and was a factor in his reasoning that he states that the plaintiffs have demonstrated a likelihood of success on their claim that Act number 395 violates the First Amendment on overbreadth and vagueness grounds, and therefore it is appropriate to grant a preliminary injunction. Now, that does not mean that the story is over, it's ending. However, it does state that the plaintiffs or the strippers have won, essentially, until the judge makes a final ruling, or if he makes a final ruling. I hope that you enjoyed this video. Please like and share it. Subscribe to the channel. We're going to keep pushing out good content, stuff that's very interesting or law related. I hope that you find it helpful, and I look forward to doing many more of these. Thanks, and have a great day.